The increasing manipulation of the legal system is indicated by larger and larger jury verdicts that are having profound effects on businesses and consumers alike. Tactics plaintiffs' attorneys use in the courtroom play a critical role. Welcome to the Future of Risk, presented by Zurich North America. In these podcasts, we explore the changing risk and resilience landscape and share insights on the challenges that face businesses to help you meet tomorrow prepared. This podcast mini-series is all about social inflation. Social inflation refers to the rising costs of insurance claims and litigation costs that go beyond general economic inflation. They're driven by societal factors rather than traditional market forces. Those factors include social attitudes, legal practices, legal system abuse, and cultural norms. The effects reach further than the insurance industry and lead to higher insurance premiums for businesses, a strain on the economy, and growing financial hardships on everyday consumers. Today, we're exploring plaintiffs' tactics, including legal system manipulation in the courtroom and how those tactics can have an effect on social inflation. I'm Al Orendorff. Today, I'm speaking with Allen Kirsh, head of Claims Judicial and Legislative Affairs at Zurich North America, and Lisa Bellino, Vice President of Claims Judicial and Legislative Affairs, also at Zurich North America. Allen and Lisa, welcome to the podcast.
Thank you, Al.
I want to start off today with a two-part question. What do we mean by legal system manipulation? And then the second part is, what role do plaintiffs' tactics play in fueling that manipulation that drives the rising cost of insurance claims and litigations that businesses are now seeing?
Yeah, thank you, Al. First of all, legal system manipulation is really a big part of what we see in driving social inflation. So it's a really important topic, and I'm glad we're talking about it. And at the top of the hour here, I want to be clear that, we as an insurer have an obligation to pay what we owe. Firmly believe that when someone is injured as a result of another's negligence, they are entitled to compensation. But what they're entitled to is, how do we make them whole again? And legal system manipulation is really when the attorneys go beyond arguing how do we make the plaintiff whole, and it really becomes more about maximizing that jury award. So how do plaintiff tactics play a role in that manipulation? It's a large one. As I said, our jury system is really designed to determine if one is negligent, then what are the damages that are owed from that approximately caused by that negligence. When it comes to economic damages, fairly straightforward, right? We're talking about lost time, medical cost, but really when it comes to the non-economic damages, like the pain and suffering, that's really where the jury is given a wide discretion, and quite frankly, not a lot of tools to figure that out. So as a result, these plaintiff tactics are really designed to maximize the jury award, and they don't really provide good guidance on what it takes to make the plaintiff whole. Instead, they're really designed to inflame the jury and in some cases mislead the jury in an effort to maximize that jury award.
Not wanting to get ahead of ourselves here, but the question occurred to me, and that is, how much do you think the lack of understanding of how the legal system is supposed to work plays into this kind of manipulation?
So how about I take that one, Al? I think That's a great question, because when any attorney walks into a courtroom, the jury expects the trial to be like they see on TV. Back in the day, it was, if LA law could do it, you could do it in any courtroom across America, right? So people already going to court with a preconceived notion of what the trial's going to be, what the legal system is, and what justice means, because it's all been tainted or morphed by television. And it's not just TV shows, it's what we see on social media, what we hear on the radio, and things like that. So people don't really understand it. And those people are basically taken advantage of by attorneys who can use that naivete to their advantage and score bigger bucks, basically, for their efforts.
Okay, let's go into those details a little bit. What are some of the frequent tactics used to help plaintiffs win cases?
Yeah, so we've really divided these into four different categories. One is the plaintiff attorney advertising that we see. And I think that plays into what Lisa was mentioning as well, in terms of the way jurors come into the system thinking the way it should be, right? They're exposed to large numbers and whatnot. Another, and we'll go into these in a little more depth in just a moment, but the rest are forum shopping, so looking for a jurisdiction where the plaintiffs can get the largest verdict. Something called the reptile theory, which is a tactic that's been used for many, many years, and we'll explore that a bit in a minute, as well as anchoring, which is really, how does the plaintiff's attorney get jurors or potential jurors to think at the very beginning of the case that it's worth a lot of money, so they anchor them on a number early on. So I'd like to start with the plaintiff advertising, and I think this is something that has really proliferated over the years. By some estimates, attorneys are spending $2.5 billion a year on advertising. And this is, of course, billboards, TV advertising. I saw one in a movie theater, not to mention social media, which is both paid and then there's unpaid with social media as well. But it's not really just the sheer amount of money and the amount of ads that are out there. It's more of the intent behind the ads. Years ago, it was how do we get people in the door? Now these ads are really focused on, well, I got this client $10 million. I got that client $20 million. And what they're doing is really letting the jurors and potential plaintiffs, for that matter, think that these really are the value that these cases are worth, when in reality, very often these are just outliers. So
it's more than just advertising. It's actually an attempt to influence.
Absolutely, because these ads are so prolific. They're just wherever you look. I mean, if you're driving down the road, you're going to see them on TV. And while it used to be late night, now it's just all times during the day, right? So they're using this in part, not just to get clients, but to indoctrinate, I would say, potential jurors on the value of this case. Now, there's another part of that as well. They've also focused a lot on insurance companies. Now, in a typical trial, the fact that there's insurance or the defendant has insurance would not be admissible. The jury would not hear anything about that. But by these ads focusing on the insurance companies time and time again, they're basically letting the jury know, even though you're not going to hear this during the trial, you need to know that there's an insurance company behind this. So don't worry, it's not the individual defendant who's maybe sitting at the defense table who's going to pay this verdict or this judgment, but in fact, an insurance company. And I think, part of that tactic ties into whatever anti-insurance company and anti-corporate bias that exists in our society. So, Lisa, any other thoughts from a plaintiff attorney advertising perspective?
Yeah, thanks. I was just going to add, it's been estimated that with respect to legal advertising, the average American is inundated with over 45,000 ads per day. That translates to about 1 every 2 seconds. And that's just legal advertising. And when we go back to that naive jury that I was talking about before, oftentimes the ads focus not on punishing the big bad insurance company or the big bad corporation, but also these ads try to, for lack of a better word, educate the average American on what the law is. And so when they give this slanted view of the law in a commercial, the juror or the prospective juror will take that into the courtroom. So they have a preconceived notion of what the law is. Statistically, it has been determined that between 46 and 61% of jurors will not follow the judge's instruction on the law. So when you ask the average American what the law is on something, they will regurgitate what they see in an advertisement. And they take that into the courtroom and award accordingly. Not what the law is, but what they've heard on TV. So that's another method of how advertising shapes and then leads to these nuclear verdicts.
Great. Thank you, Lisa. So the next tactic we wanted to address is forum shopping. And what that really means in a nutshell is the jurisdiction in which the plaintiff's attorney decides to file this action. Now, we know that there are a number of jurisdictions where we see much higher jury verdicts. In fact, ATRA, which stands for the American Tort Reform Association, puts out a list every year of what they call judicial hellholes. And these typically are certain jurisdictions across the country that are notorious for larger and larger verdicts. So it's no secret that the plaintiffs, if they can, will try to file in these jurisdictions. So, I mean, regardless of whether there's real connections to that case or not. So, Lisa, I know you live in the state of Pennsylvania, and that has some unique rules and laws when it comes to forum shopping. So if you can provide some examples, that would be great.
Sure. In 2023, the United States Supreme Court came down with a case called Mallory, in which the gentleman there worked for Norfolk Southern Railroad. He eventually developed a type of cancer and wanted to sue under federal statute for contracting that disease. He never lived in Pennsylvania. He never worked in Pennsylvania, but yet he sued in Pennsylvania and specifically in Philadelphia, which is the litigation hotspot of the entire Commonwealth. And although he had no physical contact to Pennsylvania, he availed himself of a rule in Pennsylvania that said if the company's registered to do business there, it is subject to jurisdiction there. And so he was able, after the Supreme Court looked at this case, to say, yep, you can come to Philadelphia because you can come to Pennsylvania, and it doesn't matter whether you've lived there or not. So as a result, we see in jurisdictions that are these litigation hotspots, more and more plaintiffs coming to file their lawsuits, regardless of whether they have actually set foot there, because they're worth more money there. And also, those jurisdictions have a little bit more lenient rules and procedures so that what might not be evidence in a trial in a more conservative jurisdiction may very well be in one of these more lenient jurisdictions.
Yeah, that's a good example. Thank you. The other tactic I mentioned was the reptile theory. And as I said, that's been around for a while. It stems really from a book that was written in 2009 that was actually titled The Plaintiffs' Revolution. And essentially, the reptile theory is a way of getting the jury to feel anger or even fear about a specific case. And the idea is that that anger and that fear refers to the reptilian portion of one's brain. So think fight or flight. And that would drive a larger verdict because the jurors then encouraged to, quote unquote, send a message to this defendant. If you want to protect your community, your family, then you will send a message by a very, very large verdict. So years ago, it was thought that sympathy played the biggest factor when it became to, larger and larger verdicts. But one of these attorneys was a psychologist, and they came up with this theory that it's really this fear that's going to drive a larger verdict. And it does resonate with jurors. So Lisa, in your practice, I know you've encountered the reptile theory quite a bit. I was hoping you can provide some perspective on this.
Sure. One of the main features of the reptile theory is, in conjunction with that fear aspect of it, is to make that fear turn into something else. And they oftentimes refer to it as making the jury the conscience of the community, so that the jury feels the need to protect people and therefore not necessarily follow the law that the judge gives them, but do their own justice so that it doesn't happen to them or their loved ones. A real concrete example that we see, let's take a construction case, for example. I saw this many, many times. Under the standard agreement between the owner and the contractor, there is a specific responsibility for safety, and it is spelled out. What it means and what it's used for in a trial are completely different things. And plaintiffs' attorneys will hone in on this one section to make it look like the contractor is responsible for essentially wrapping any of the workers there in bubble wrap so that they're not responsible for their own safety at all. In fact, even if the contractor provides every potential safeguard and the person gets hurt because they disregard those safeguards, they will turn that against the contractor and say to the jury, look, you have to protect your loved ones too. Don't let this happen to you. So not only are we seeing large awards, we're seeing punitive awards because the jury wants to punish anybody that allegedly may cause harm to anyone else. And this theory is very, very effective.
Yeah, that's a really good point. And when you use the word punitive, there are not necessarily punitive damages claimed in that case. It's just the award itself for negligence tends to be more on the punitive side, right? Because they're responding to that sense of anger, correct?
Yes.
So the last tactic, we wanted to talk about was anchoring. And I mentioned this a little bit at the intro, But essentially what anchoring is indoctrinating the jury early on in terms of the value of the case. So the way this comes about is even during jury selection, when the attorneys are allowed to ask jurors questions, and a plaintiff's attorney may ask the question, are you comfortable awarding $25 million in this case? Are you comfortable awarding $50 million in this case? And, their point is not really, it's partly to find out if they are comfortable with that, but also it's letting them know this is what we think this case is worth, right? So that juror, right from the very beginning, before they've heard a shred of evidence or even met the parties, are thinking, oh, wow, I guess this case is worth a lot of money. I would also mention, because we talked about advertising before and how this all ties back into this national form of anchoring by prospective jurors having this sense of an outsized value of these cases. So Al, all in, these are the four probably main categories of plaintiff tactics that we see most often and that I think are most influential.
I've got a couple of follow-up questions to this. So I remember in the old movie Ben-Hur, the Roman tribune Messala asked a rhetorical question about how do you fight an idea, and he answered his own question by saying, with another idea. And so I'm curious as to how you can offset this fear that you put in the hearts and minds of juries. What do you do to fight that?
That's a really good question, Al. You could look at it theoretically, or you could look at it tangentially from the perspective of the average trial attorney. I will say that the way to practice law in a courtroom anyway has changed significantly in the last 20 years. We have developed our own methods of what we call anti-anchoring so that we are ready to explain to the jury why any number that we might suggest would be best and most reasonable. We have learned how to deal with reptilian tactics and actually even use them against the plaintiff whenever appropriate. We file the appropriate paperwork to make sure that a case, if possible, will be taken out of one of those unfavorable jurisdictions or venues when they are not properly there. And we even have developed ways to deal with attorney advertising in our voir dire as well as during trial so that we can attempt, at least as best as possible, to counteract those measures. I will say, though, it's kind of like a drop in the bucket because the plaintiffs are so far ahead of us, even just with the advertising. When somebody sees something 1,000 times a day, it's kind of hard to say when you stand up in front of them, disregard, that altogether, pay no attention to the man behind the curtain when people have only seen that all the time. So there are ways, but they are difficult.
And I would say, Al, to summarize that, really, it's preparation, right? So a lot of the work that we do is around educating our customers, educating our broker partners, educating our claim professionals, educating judges on this. Lisa's done a lot of great work in some of the judicial areas where we can really let judges know what these tactics are and what they're trying to do. A big part of it is talking to our defense attorneys as well. So, knowledge is power. So if they understand what these tactics are, what are going to be used, as Lisa mentioned, there's a number of things that we can do proactively to kind of push back on that, if you will, and offset it, to answer your question.
And adjacent to that, I'm also very curious about the role institutional bias may play in this legal system manipulation. All companies are bad and therefore deserve to be punished.
Well, it does. And the anti-corporate bias is pretty well documented. And for that, it's really important that the defense attorneys tell their story. Typically defense attorneys were probably more focused on, picking apart the plaintiff's case on this. But what's important is storytelling here. So as the defense can tell its story, and when the plaintiff uses comments like they're putting profits over safety, it's really important for the corporate defendant to really explain how that's not the case and how safety is extremely important to us and to our customers, and that no one's interested in seeing somebody get injured, whether it's a work site or a car accident or a premises liability, right? So again, there's a number of ways that we can use to really push back against that anti-corporate bias. but it does play a part and it does exist, and we have to be cognizant of it.
You listed this short list, but powerful list of tactics. How successful are these tactics in swaying jury decisions? I mean, you've explained them so clearly, you would think that some folks would see them as what they are, but obviously they're having an impact.
They are. And I mean, the demographics on this are in the plaintiff's favor. A number of studies have been done looking at jurors through a demographic lens. And younger jurors are certainly more susceptible, and I think Lisa referenced this as well, to the argument that you are a protector of your community, of your family, of your society, and that these cases are taking on a larger meaning. When, of course, the whole point of the civil justice system is to address the case you have immediately in front of you. So when you overlay that with the demographics, I would say that they are very successful. And when you think of reptile theory, for example, it's based on a psychological principle, and it's very, well documented, right? So, and for that reason, a lot of courts have not allowed the reptile theory to be used because they see it for what it is and just a way to manipulate the value of the case. Again, I'm going to reiterate that the point of our civil justice system is how do we make the plaintiff whole again? Not how do we maximize the number, but what will it take to make the plaintiff whole again when it comes to the non-economic damages.
Are these types of tactics acceptable to the courts? I mean, they have to know this is happening, right?
So that's a great question, Al. Depending on the jurisdiction, it may very well be acceptable. And I'll give you an example. In New York, anchoring is permitted by statute. It's built right into the civil justice system. But last year in Texas, the court said, equating the potential loss of life's enjoyment or of pain and suffering to an expensive painting or a fighter jet or a ball player's salary, because it's so not related to the case, is not acceptable. We can't allow people to be compensated for their injuries based on something that has no reasonable basis in reality. And so you see completely different avenues here. And of course, then you see the plaintiff taking advantage of whichever avenue will allow them to do whatever tactic will make them the most money. So it's acceptable in some courts. The question then becomes, how far can the envelope be pushed? Same thing with the reptile theory.
Now, I have another two-part question, or I guess two adjacent questions. And the first one is, what can be done about this? But the second part to that, maybe a sub-bullet, would be, I know that one of the ways to combat this is through legislative reform. Going back to, I think, a point that Allen made earlier, do our own legislators know enough about the court system? I know many of them are attorneys, but not all, to effect the kind of change that will be necessary to combat this kind of legal system misuse.
So the first part of your question I spoke about a little bit ago regarding education. I mean, just as I said, knowledge is power. And I think educating our customers and our brokers is such a key part of this, as well as the defense attorney, so that they know about it. So what can be done is very active. Once a claim occurs, how do we investigate early, preserve evidence appropriately, make sure that we're interviewing all the witnesses, just do a solid job of investigating and truly understanding what this accident or injury is about, what the liability is about, and doing, I think, the best job that we can do to make sure that we can get to the truth, right? But you brought up a really good point about legislative reform. So right before the accident happens, what's the law? And what does that take? So, we in our group, and we stood this up at Zurich a little over 3 years ago as kind of a social inflation task force. The idea being that, what can we do to advocate on behalf of tort reform across the country? And you are right. A big part of that is educating our legislators, letting them know what is happening and what is about. When I first went to Florida to speak to some legislators on this issue, I had to provide some really specific examples because some of them were not attorneys and just were not familiar with it. And even some who were, maybe they didn't practice in this area. So, providing those specific examples to them, I think really got them to understand what the impact was, as well as the various studies that show the impact that this has to society as a whole. It's not just an insurance company or a business that's paying, but with these increased costs, they get passed on to everybody. And that's where the legislators care the most about their constituents and what's the impact on them, as well as businesses and the impact on their insurance rates and where that's going. So Florida is actually a great example because in 2023, the legislature and the governor passed historic tort reform legislation. And through that, we've seen some real wins in terms of the insurance environment in Florida. The timing of this is good because just recently, the governor of Georgia, Governor Kemp, had a press conference where he talked about some sweeping tort reform to address a lot of the same issues that they're seeing in Georgia. So we're seeing really good momentum on this in terms of how do we level the playing field. No one's looking for an advantage here. What we want is how do we level the playing field so that both sides can tell their story and that a jury can render a verdict based on the facts and what is due and owing in that case. Now, of course, tort reform doesn't happen in a vacuum. So what we've done as well is to really lead a coalition, an industry-wide coalition of insurers, of customers, of brokers, a number of tort reform associations to really align on what are the priority jurisdictions, what are the priority issues that we want to focus on. And since we've been able to start this coalition and get our groups focused on certain areas and certain issues, may not agree on everything, and that's okay, but we can do more together than we could individually. So Lisa, I know you have some thoughts about this as well.
No, I agree with everything that you said. And I think that the more we educate the average person who's going to walk into a courtroom and be a juror, the better off we are. It's very difficult to move mountains, but if you move them one rock at a time, you're going to make a big difference. And so we aim to assist our customers by educating them, and in turn, the word gets spread so that hopefully we're educating the public as well, that this is an issue, it needs to be addressed, and it will behoove all of us to be moving in the same direction.
Lisa, you and Al have done a great job of laying out the problem as well as the solutions to address it. But as we wrap, I'm curious as to, this is a tall hill to climb here because it's so entrenched and there's a lot of money involved. How optimistic are you that we can affect the kind of change that we're talking about?
First of all, I'm very optimistic. I'm very excited about Georgia at the moment, so I'll be living off that for a little bit. But you make a good point. Look, the plaintiffs' bar is very well organized, very well funded, and quite powerful. And they're not giving up, as an opponent usually does not. This is a long game. We need to continue to, focus on those jurisdictions that there's the most imbalance on, and that's what we're doing. But the bottom line is that, as I said, this affects all of us as citizens, and it increases costs for all of us. And while we absolutely agree that, someone who was injured from someone else's negligence is deserving of compensation, the nuclear verdicts that we've seen, which are typically $10 million and above, are not reflective of that. And so I think the more we get not only legislators, but the public to understand that and to feel that impact, that's where the groundswell of support will come from. And so for that reason, we're very optimistic that we can get it done. There's no silver bullet. It doesn't happen overnight. It does take time, but we're seeing that incremental movement. So it's moving in the positive direction.
Lisa, your thoughts?
Well, again, I agree with Alan, but I have a little bit of a different perspective. And that is, nobody said it had to be fun. Nobody said it had to be easy. It just needs to be done. And so our job is to get it done. And I am optimistic that we will get our job done because it's not just about Zurich. It's about everybody. And we take that very seriously. We wouldn't have picked up this gauntlet if we were only in it for ourselves. So I am optimistic that we will make a difference. Thank you.
And thank you for listening. If you like the show, leave a comment or review wherever you get your favorite podcast, or drop us a note at media@zurichna.com. Stay tuned for the final episode in our social inflation miniseries. We'll discuss premises liability with Rebecca Fozo from Zurich North America and James Beal from Georgians for Lawsuit Reform. This is truly a fascinating topic that you won't want to miss. This has been Future of Risk, presented by Zurich North America.
Future of Risk, presented by Zurich North America. If you like the show, we'd appreciate it if you left a comment or review wherever you get your favorite podcasts. Let us know what you think at media@zurichna.com and join us next week.
The information in this audio recording was compiled from sources believed to be reliable for general information purposes and is intended for Zurich clients and business partners. The information contained here may be useful to you or your enterprise when developing your own policies and procedures. The policies and procedures applicable to your enterprise should take into account the specific circumstances of your business and business environment, which is beyond the capacity of this podcast. Any and all information provided is not intended to constitute advice of any nature and is specifically not legal advice, and accordingly, you should consult with your own legal counsel. We do not guarantee the accuracy of this information presented or any results and further assume no liability in connection with this recording and the information provided therein. Moreover, Zurich reminds you that the information provided cannot be assumed to contain every acceptable safety and compliance procedure or that additional procedures might not be appropriate under the circumstances. The subject matter of this recording is not tied to any specific insurance product, nor will adopting these policies and procedures ensure coverage under any insurance policy. We encourage listeners to seek additional information from credible sources. Thank you.